From a legal point of view, when buying property in Malta, what should one look out for?
In such cases, the best thing is to look at the worst-case scenario and see what one can do to mitigate or eliminate completely the risks associated with that scenario. In the context of property purchase, the worst-case scenario is buying a property that has a defective title or is burdened. The process of purchase in itself has a number of steps that mitigate or eliminate this risk. The customary process is that you sign a promise of sale agreement whereby the purchaser promises to buy and the seller promises to sell a particular property. This promise of sale agreement is usually subject to a number of conditions. One important condition is that searches are undertaken into the title of the property to ensure that the title is in fact in order. So in practice, what happens is that the notary will make these searches and together with the legal representative of the purchaser will vet these searches to ensure that the owner, the seller, is actually the owner of the property and is entitled to sell the property, and that there are no burdens on the title of the property, or if there are, they are cancelled before the final deed of sale. The law itself provides for a number of warranties that the seller is to provide to the purchaser. One such warranty is the warranty of peaceful and quiet possession, whereby the seller guarantees the peaceful and quiet possession of the property to the purchaser, so guarantees against any acts of eviction or burdens. Another typical warrant is that of the latent defects, so the warrant against latent defects. The seller would guarantee that the property has no latent defects. It is important to note that this warranty is in relation to hidden defects and not those which are apparent. Those which are apparent are the ones that the purchaser should have noticed before he bought the property. Other risks associated with the purchase of the property include having a property that is not structurally sound or not built according to law or according to permits. The way to mitigate this risk is to make the promise of sale agreement conditional to an architect's inspection. So the architect will go to the property and make sure that it is according to law and of sound in structure. There are also warranties that the seller normally gives to the buyer on the final deed of sale in relation to this, including that the property has been built according to permits and to law, that road and drainage contributions have been paid, and that all dues in relation to the construction of the property have been paid as well. If the purchaser, on the other hand, is a person that requires a permit to buy property, it is important that a condition that a permit is obtained is inserted in the promise of sale agreement. This to avoid a situation of incongruency where you have a purchaser that is willing to purchase a property but cannot at law.
What permits are we referring to here, and how are these permits obtained?
Yes, indeed, Maltese law lays down a number of situations where a permit is required for a purchaser to be able to buy a property. Whether a permit is required or not depends on the nationality and the residency of the purchaser. In those cases where the purchaser is an EU citizen and has been living in Malta for 5 years or more, no permits are required. That such a purchaser is free to buy any property in Malta without any restrictions. In the cases of EU citizens which do not satisfy the 5-year rule, then they can buy property for their residency in Malta without any restrictions. When it comes to the second property for a holiday home, they would need a permit. In the cases of non-EU citizen, then a permit is always required. When we speak about legal entities, there are no legal restrictions as long as 75% of the shareholding is held by EU citizens. In case of properties inherited or through succession, received through succession, there are no limitations. It is important to note here that in Malta we have what we refer to as special designated areas. These are areas of high-end properties specifically constructed to attract the foreign investors, and therefore in relation to properties situated in these areas there are no restrictions and no permits are required irrespective of nationality or residency.
Finally, although not a legal risk, which are the best areas to buy property in Malta for a safe and sound investment?
Generally, property in Malta holds its value. There is an annual appreciation of 7.5% when it comes to price and value of the property. So the choice of where to buy the property is more based on the purpose, the use of the property. The sister island Gozo is particularly known for retirement plans because it provides a calmer and more peaceful environment. The center of the island of Malta, on the other hand, is busier and closer to the entertainment areas and the offices of the new industries such as ICT, digital gaming and iGambling. Families tend to buy properties in towns and villages where the locals live, whilst, as we said before, the special designated areas are mostly attractive to foreign investors, either as a holiday home or alternatively as an investment. Malta, however, also offers the opportunity to buy a property which is hundreds and hundreds of years old, and therefore renovating that property, literally buying a piece of history and converting it into a gem in the center of the Mediterranean.